Greetings and welcome to Courts this week on LiveLaw. I am Taniya Pandey, here with our weekly update from courts across India. To those who are new here, we welcome you. If you want to find out about what happens in courts every week, do subscribe to LiveLaw and click the bell icon. Let's begin the episode with judgments from the Supreme Court. The Supreme Court on 7th October put several serious questions to the Union government regarding its decision to adopt the criteria of annual income of Rs 8 lakhs to determine economically weaker sections for the purpose of reservation in the All India quota for seats under NEET. A bench of Justices D.Y. Chandrachud, Vikram Nath and B.V. Nagaratna was hearing a batch of petitions challenging the decision of the Union government to introduce 10% EWS and 27% OBC reservation in NEET All India quota, and asked the Additional Solicitor General regarding the studies and deliberations undertaken for fixing this criteria. The ASG informed the court that the same criterion of 8 lakhs is there for determining creamy layer under the OBC quota. The bench pointed out that there is no concept of social backwardness for economically weaker sections category, and hence the creamy layer criterion for the socially and educationally backward classes may not automatically fit the former. The Supreme Court on 7th October directed the Centre to make arrangements for the induction of girls into the Rashtriya Indian Military College RIMC by allowing them to appear for the upcoming examination on December 18, 2021 for the term beginning from June 2022. The Centre was directed to issue fresh advertisements in this regard. The Additional Solicitor General sought the court's leave to allow for the induction of girls into the RIMC and Rashtriya Military School for the term beginning from January 2023 and not June 2022. The bench refused to accept such a contention and held that 6 months' time was more than enough for adequate preparations to be made for the induction of girls for the June 2022 session. The Supreme Court has taken suo motu cognizance of the Lakhimpur Kheri violence, where in a recent violent incident, a total of 8 people died, 4 of whom were mowed down by a vehicle allegedly being driven by the son of Union Minister and BJP MP Ajay Kumar Mishra. The bench of CJI N.V. Ramana and Justices Suryakant and Hima Kohli expressed dissatisfaction at the investigation being done by the Uttar Pradesh police and remarked that handing over the probe to the CBI also may not be a solution because of the persons involved. The bench expressed unhappiness over the fact that the UP police has not yet arrested the prime accused and has instead only issued summons. The court said that they hope the state will take necessary steps to satisfy the court by the next date, which has been fixed as October 20th. In furtherance of the court's order, the accused has finally been arrested on 9th October. The Supreme Court on 7th October declared that the National Green Tribunal is vested with suo motu powers to take cognizance on the basis of letters, representations and media reports. A bench of Justices A.M. Khanvilkar, Rishikesh Roy and C.T. Ravikumar delivered the judgment on a batch of petitions which raised the issue whether the NGT has suo motu jurisdiction. In the judgment authored by Justice Rishikesh Roy, the court held that the NGT must be seen as a sui generis institution, as the National Green Tribunals Act 2010 provides the tribunal with wide-ranging powers beyond that of a mere adjudicatory body. The court also acknowledged that environmental impact on climate change is gaining increasing visibility in recent times, and the NGT must be given the discretion to exercise suo motu powers in order to salvage adverse environmental consequences for generations to come. The Supreme Court has issued guidelines on the aspect of grant of bail to accused who are not arrested during investigation on the charge sheet being filed. Last week, the bench of Justices Sanjay Kishan Kaul and M.M. Sundaresh had observed that it would be appropriate to formulate some guidelines so that the courts are better guided and not troubled with the aspect of bail on charge sheet being filed. These are the guidelines that have been issued, and the top court has ordered that a copy of this order be circulated to the registrars of different high courts to be further circulated to the trial courts so that the unnecessary bail matters do not come up to the Supreme Court. The Supreme Court on 6th October directed the suspension of Tihar jail officials who had extended undue help and assistance to ex-Unitech promoters Sanjay Chandra and Ajay Chandra while they were in jail. Earlier, the court had directed shifting of Chandra brothers from Tihar and ordered probe by the Delhi police. On August 26 this year, a bench of Justices D.Y. Chandrachud and M.R. Shah had directed the Delhi Police Commissioner to carry out a probe against the Tihar jail staff on the basis of the Enforcement Directorate's report. In light of the report submitted by the Delhi Police Commissioner, the bench ordered that the officials who have been prima facie found to have connived with the Unitech accused be placed under suspension pending inquiry. The Supreme Court has observed that Lok Adalat has no jurisdiction at all to decide the matter on merits once it is found that compromise or settlement could not be arrived at between the parties. The jurisdiction of the Lok Adalat would be to determine and to arrive at a compromise or a settlement between the parties to a dispute, the bench of Justices M.R. Shah and A.S. Bopanna said. Relying on its judgment in State of Punjab versus Ganpat Raj, the top court added that once the settlement or compromise fails, the Lok Adalat has to return the case to the court from which the reference was received. The court also rejected the contention that once the matter was placed before the Lok Adalat with consent, the entire matter is at large before the Lok Adalat, and therefore the Lok Adalat is justified in disposing of the matter on merits. The Supreme Court has observed that the requirement under Section 19 of the Micro, Small and Medium Enterprises Development Act of deposit of 75% of the awarded amount as a pre-deposit while preferring the application or appeal for setting aside the award is mandatory. In this case, the High Court of Uttarakhand had upheld the order passed by ADJ Commercial, Dehradun, in which he directed a party who preferred a petition under Section 34 of the Arbitration and Conciliation Act to deposit 75% of the awarded amount in terms of the Act. In appeal before the Apex Court, the issue raised was whether the appellate court would have any discretion to deviate from the deposit of 75% of the awarded amount as a pre-deposit. The bench of Justices M.R. Shah and A.S. Bopanna noted the 2012 judgment in Goodyear India Limited, in which it was held that requirement of deposit of 75% as a pre-deposit is mandatory. However, if the appellate court is satisfied that there shall be undue hardship caused to the appellant in depositing 75% of the awarded amount as a pre-deposit at one time, the court may allow the pre-deposit to be made in installments. Let us now go over judgments from the High Courts and other courts. The Delhi High Court has issued notice on a review petition challenging an order dismissing a plea seeking to declare the assumed absolute discretion of the Muslim husband to give divorce, that is talaq ul sunnat, to his wife at any time without any reason or advance notice to her as arbitrary, anti-Sharia, discriminatory and unconstitutional. It was argued that the review plea has been filed because talaq ul sunnat, being a revocable form of talaq, is not covered under the definition of talaq under Section 2, Clause C of the Muslim Women Protection of Rights on Marriage Act 2019. Talaq ul sunnat is also called as revocable talaq because it does not become final at once, and there always remains a possibility of compromise between the husband and the wife. Dealing with the PIL involving certain grievances of the transgender community in the state of Assam, the Guwahati High Court on the 7th of October asked the Union and the Assam State Government to specify steps taken in terms of the Transgender Persons Protection of Rights Act 2019. The bench of Justices N. Koteshwar Singh and Manish Chaudhary said that before going into the various issues raised in the PIL, the court wants the state as well as the central government to apprise this court as to the steps taken in terms of sections 13, 14 and 15 of Chapter 6 of the Act. The case will next be listed before the court on 11th November this year. The Delhi High Court has observed that in households where women are working and are able to sufficiently maintain themselves, it does not automatically absolve the husband of his responsibility to provide sustenance for his children. The observation was made in connection to a revision of maintenance order passed by the High Court under Section 125 of the Code of Criminal Procedure. Justice Subramaniam Prasad observed that a mother cannot be burdened with the entire expenditure for raising and educating the children. Dera Sacha Sauda Chief Gurmeet Ram Rahim Singh has been convicted by the CBI court on 8th October in the Ranjit Singh murder case. Special CBI court judge Sushil Garg pronounced him and others guilty and he would next be heard on October 12th on the point of quantum of punishment. Gurmeet Ram Rahim is already serving sentence for the offence of rape, and he has now been convicted for the murder of his disciple Ranjit Singh. Along with him, 4 others have also been convicted on murder charges. A chief metropolitan magistrate in Mumbai has rejected the bail applications filed by Aryan Khan, Arbaz Merchant and Munmun Dhamecha, accused in connection with the seizure of drugs on a luxury cruise ship off the Mumbai coast on the ground of maintainability. Additional Solicitor General Anil Singh, appearing for the Narcotics Control Bureau, relied on Section 36A of the NDPS Act to argue that the offences alleged against the accused are exclusively triable by the Special Court of Sessions under the NDPS Act and not a magisterial court. Magistrate R.M. Nerlikar accepted the submissions and rejected the bail applications, finding them to not be maintainable. With this, we come to the end of today's episode. If you found these updates helpful, don't forget to subscribe to LiveLaw and click the bell icon to not miss any videos from us. I am Taniya Pandey and you're watching Courts This Week. I'll see you again very soon. Have a wonderful week ahead.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.